Hi. I found Chris Srinka's presentation very interesting, and I shared a slide with him recent. It's totally not my topic, but I found it fascinating that it's an FBI study on how long it will take to break your passcode with what's called brute force, which isn't some Asian kid typing your combination. It's an algorithm that runs through there. And if your number of characters is 5, it doesn't matter if they're numbers, lowercase, uppercase, or symbols, the algorithm can do it almost instantly. That's assuming that your phone or whatever device doesn't shut them down after X number of attempts. And then they give how long it would take depending on the number of characters you use. And I found it reassuring for myself because mine's 11 characters long and it includes upper and lower case and symbols and numbers. Then it would take about 400 years. And if you want to get up to 13 symbols, I think you're safe for 2 million years to break your passcode. So last night when I was looking at this, I just about did the same thing. I'm working in my office and my 11-year-old daughter is making a TikTok video of cooking something, and she asked me what she should do if her phone fell in the pot of boiling water. I did not have an answer. I'll try to avoid that here. Okay, we're here today to talk about the Governmental Immunity Act of Utah. And part of that act contains a section known as the Public Duty Doctrine. It used to be a wholly independent judicial doctrine. About 10 years ago, they finally added it to the act. And then also, we're going to be talking about the another piece of legislation called the Limitation of Landowner Liability Act. Now, this applies to public and private landowners, not just governmental entities. Can I get rid of this? Is this? I think it's going to attack me. Okay. So I don't know how much of this you can see. I'm going to talk all of this outline. Don't feel obligated to try to find everything that I put in here.
Your cords are after it. You can right off of your laptop. You can see them right off that.
Thank you. This is really overkill.
This is the one that broadcasts to those who are joining us virtually.
Oh, I see.
So this one doesn't have any effect on the house, but if I come in really close, those who are listening can hear it.
I see. Thank you. I got 3 microphones here. I feel like I'm announcing.
I don't think this one is even on.
Oh. Okay.
So that's the one that counts for all of us here. This is the one that counts for all of us joining virtually.
All right. Now you know. All right. So stepping back on the Governmental Immunity Act of Utah. So I think most people are familiar with the concept of what we call sovereign immunity, or King's X. And it came down from English common law. Back in the day, you could not sue the crown, king, the government, or anything. They had absolute immunity. And that concept and doctrine was transferred down to America. And for a long time, that was the rule. And slowly in the 20th century, many states began to allow for some cracks in that. And it was fair because government began to do more and more than it did in jolly old England. And people were having issues that they needed remedies for. And so in 1966, the Utah legislature joined the club and provided some remedies or waivers to governmental immunity. And for a long time, the way the Governmental Immunity Act was written was, and find dozens of cases that say this. Government's immune. However, there may be some waivers to that immunity. However, there may be some exceptions to that those waivers of immunity. And for many years, that's exactly how it was written. And I don't know why. Maybe somebody in here that can explain to me why our legislature decided to move things around a few years ago, but it's really difficult to actually discern that from a sort of a analog serial reading of the statute now. The statute still provides that everything the government does is immune. They're going to waive some of those immunities, and there's going to be some exceptions. One of the important things up front is that the legislature's definition of governmental function is different than the courts or appellate courts. So our legislature, if you read the act, says everything you guys do, governmental function, don't worry about it, and make you go through that process. The courts, on the other hand, don't do that. They rely on a distinction between what is known as a governmental function versus a proprietary function. And a proprietary function is, the best definition is, if it's capable or being done by a private entity, then it ain't a governmental function. And so you get down to some core things like fighting fire, police protection, dispatching, flood control, things that the government has to do, are what the courts are going to say are governmental functions. And then you can go through and say, well, has it been waived or is there an exception? As currently written, though, if you didn't peek behind the curtain to see what the judicial interpretations of the act are, one would read the act to say, okay, the city was hosting a softball tournament. That's a governmental function. And if somebody got hurt and sued the city, immunity's been waived, or there's immunity for that. Has it been waived? Is there an exception? I don't think that's going to fly. I had a case, it was about 8-9 years ago, represented a water conservancy district, and there was a broken pipeline, an aging pipeline in Murray and South Salt Lake. It ruptured. It flooded this nearby home. My client, the water district, was going to do what it always does and say, we're sorry this happened. What kind of damages did it cause? Let's get you a new water heater, the whole 9 yards. So they asked the homeowner, okay, you need to have all this stuff available for us to look at when we come, because we're going to write you a check and pay you the price of replacing that stuff. And when they showed up, there was no stuff. There were pictures of stuff, but the homeowner said, I want to be paid. I donated this. They said, we're not going to pay you if you donated it, so we need to see it. And I'll be darned if he didn't stand his ground and say, well, this is all the stuff that was damaged and you need to write me a check. So for one of the first times ever, they pushed back and they said, well, yeah, we normally take care of you, but we're not if you're trying to, game the system. And so they ended up getting sued by the homeowner. So for one of the first times, we actually had to defend a claim that we would normally settle. And we went through discovery. I found out in discovery, I asked the homeowner, what'd you do with the stuff? He said, oh, it's in a trailer over at my uncle's pawn shop. Okay, well, that would have been nice to mention a lot earlier than litigation, but nonetheless, it wasn't available. So we filed at the end of discovery, we filed a motion to dismiss the case. And we argued governmental immunity, public duty doctrine, and the fact that these guys did not have an expert witness to support their main theory, and that is that the water district should have replaced an aging section of pipeline sooner than it had. And I'm sure you all know how capital budgets work and priorities work, and my client had 400 miles of pipeline underneath the valley that a lot of it's 50 years old. You can't wholesale replace it all. So it becomes a budgetary issue, and they had prioritized it, but not apparently fast enough. So that's what we argued was you can't just say that somebody with a $60 million a year budget should have done something sooner without knowing how that works. So those were the three issues that we briefed. And the trial judge granted our motion on the public duty doctrine, which I'll explain in a second. Plaintiff appealed. We went to the Utah Court of Appeals. The Utah Court of Appeals reversed. And this is Judge McHugh, who's now at the 10th Circuit. And Judge McHugh's reversal was based on her opinion that water conservancy districts are not performing governmental functions and therefore not entitled to immunity, which, believe you me, I got a few phone calls the day that opinion came out from various people saying, what have you done? She analogized the case to an old case out of Provo and Ogden that held that municipalities that are selling water are not performing a governmental function because any fool can sell water. And we took that, we petitioned for cert to the Utah Supreme Court, and they accepted it. So we got to argue this a second time and to point out that water conservancy districts are fundamentally different than cities selling water to their residents. There's no private entity that does what water conservancy districts do. Name a private entity that has a program to encourage you not to use their product, right? Slow the flow. And that have 50-year plans of gathering water. And so we tried to explain that fundamental difference to the Utah Supreme Court. They didn't get to that issue, constitutional issue, because they agreed with us that the plaintiff needed an expert to make this claim in the first place. So we got all three hits, but thankfully on the third round with the Utah Supreme Court, they did what we asked them to do, which was to vacate McHugh's opinion. So there's no longer a case out there that says water conservancy districts are not providing a governmental function. The reason I tell you this story is because of this difference between what the courts think are governmental functions and what the legislature says are governmental functions. We'll get to that in just a second. Okay. So I thought about how do I tell people what the Governmental Immunity Act is without actually using the act. And it's a difficult thing to do because there's specific language and specific orders that things appear in the act. And you have to understand how the act is structured if you're going to understand how it applies to your organization. So the first part, Section 101, explains the scope of the waivers and the immunity. You got to read that because that's the one that says that the waivers of immunity are subject to the exceptions. If you didn't read that section, you wouldn't know that. So, for example, everybody know what a notice of claim is? Notice of claim, you got to send to the entity before you sue them. From a very reputable law firm, one that's been around for 100 years, that said, here's our notice of claim for our clients. And by the way, we notice that you're immune from claims arising from fighting fire. However, those have been waived because there's a section that says claims for negligence are waived. They didn't read the first section, which said, hey, if you're going to talk about a waiver, these exceptions apply first. So that's important. The second section, definitions, the only reason it's important, there's only one definition in there that's really important, it's governmental function. And it says basically everything the government does is a governmental function. That's great for the legislature. That's great for you. I don't necessarily think that's something that the Utah Supreme Court is going to agree to. You have to understand that until 19 86, I think. The test there was no definition of governmental function in the act. And so everybody relied on this proprietary governmental test. And I won't go into too many details, but somebody got hit that the legislature didn't think deserved to be hit. And they said, well, we'll be the ones that define what a governmental function is. And that's when they said everything you do is a governmental function. And then a case came out called Laney versus Fairview. Farmer Laney out in his field swinging sprinkler pipe above his head, contacts a high power transmission line that was run by Fairview City and was killed, electrocuted and killed. And the city argued that they were immune because of a concept called discretionary function. It's one of the exceptions to immunity. A discretionary function is basically if a governmental entity has a reasoned, policy-based, budget-based reason why they're making a decision. They may decide it would cost us $1 billion to do it this way, but if we only spend $1 million, we can do it this way. Somebody that wants to come back and second guess that decision, your defense is it's a discretionary decision and it's entitled to immunity. And that's what the city argued. And that's what the district court accepted. That went up on appeal and the Utah Supreme Court reversed, saying supplying power is not a governmental function because there's a lot of entities out there. In fact, the majority of entities that supply power are private entities. So they reversed and said, we don't really care that the legislature said everything the government does is a governmental function. What we care about is proprietary versus governmental. And that conjured up a 2004 major effort by defense attorneys and legislatures to rewrite it used to be called the Utah Governmental Immunity Act. It was then called the Governmental Immunity Act of Utah. And they dressed it up, added a bunch of words, added a bunch of remedies to make it easier for plaintiffs' lawyers to find the right person to sue, lengthen time periods, increase damage caps, and what they were relying on was a line of cases that say, if the legislature so encompasses an area of law that they're entitled to some deference by the court when the court is addressing it, similar to workers' compensation. That was before, and then they rubber stamped it and sent it out and said everything you do is a governmental function. That was before Judge McHugh's decision. So Judge McHugh didn't care much, and I can't blame her. It was a majority opinion. I'm not putting it all on her. But the Utah appellate courts didn't much care whether the Immunity Act was dressed up and retooled and renamed and all those things. They fell back on their proprietary governmental distinction. So how does this work for you? Well, the main way it works is most personal injury lawyers don't know that. And it's just been amazing that I've had claims that we were able to resolve that literally involve things like sponsoring a softball tournament because they believed that the Governmental Immunity Act would apply, that the caps would apply, and were willing to resolve the case. The good attorneys get down in the weeds and understand the differences and the judicial interpretations of that act. And that's why that's an advantage for governmental entities, because on the face of it, the governmental immunity statute looks like it has more teeth than what it might have if you get down into the judicial interpretations. All right, so the Section 201 defines the activities that qualify for immunity. And It lists a number of them. Section 301 then lists the waivers. And we'll get to that in a second. So 1, 2, and 3 are the important sections. 1 says, hey, exceptions trump waivers. 2 says, here's your list of immunities and exceptions. 3, they put in waivers third. I don't know why it makes sense, because historically the act has always been read to say, you're immune, it's waived, here's your exception. Now the waivers come third, and they explain that that's not necessarily the order in section 101. So section 4 of the act is important, because that 401, 402, 403 define what's required in what's called a notice of claim. So before anyone can sue a governmental entity or their employee, they have to provide that entity with what's known as a notice of claim. And it's very specific about what needs to be contained within the notice of claim. It's very specific on who that notice of claim is served on, and it's very specific on when that has to be served. And if you screw up any of those things, it's jurisdictional. You're out. And I can't tell you how many cases over 30 years of practice I've seen that were just screwed up from the beginning. And so one thing you have to be sure of when you're looking at a notice of claim, compare it with what the statute requires. Compare it with who has to be served from your organization and see if it contains all of the information. Now, they recently tinkered with that last legislative session to put in a requirement that the entity respond that they've received the notice of claim, and to inform the person who sent it or their attorney whether or not they served the wrong person. And for years, that wasn't the case. So you could just sit back, wait for the time period to expire, and then move to dismiss. And they're routinely granted. I can't tell you how many cases are out there where people just, I shouldn't say people, plaintiffs' attorneys just didn't read the statute. And when they did that 2004 rewrite and dressed it up and called it all kinds of new things, they put a lot of protections in for these traps for the unwary, they call them, including a government database that you can go to, anyone can go to, and that lists the person from your organization who is authorized to receive the notice of claim. That's one thing they did, because it was, and I kind of agree with this, it was always this game of kind of cat and mouse of, oh, you served that person, not this person, or oh, you left it at the front office, not with the receptionist. And people were confused, rightly so. And so the legislature in that 2004 rewrite built in some protections to make sure people were able to serve the right person. And we'll get to that in a second. So you got 1, 2, and 3 define your immunities, your exceptions, and your waivers. And then 4, that section defines what's required in the notice of claim. The next important section is section 6, and that defines what governmental immunity caps are. So there's caps on damages against governmental entities. And until 20 years ago, that cap had pretty much stayed the same. Well, what they built into the act now is every 2 years, a fiscal analyst, somebody at the state, crunches some numbers and figures out what the cap's going to be. And it's there's growth factors and there's discount factors. And anyway, it's gone up and up and up and up. And so when I started to practice, I think it was like 100,000 per injury, or 250 for a group of injuries. It's now about, I don't know, Brian, what is it, 780,000 now? Yeah, so it's almost 800,000 for one person. It's 3 million for an aggregate. And then the property damage, I think, is about 300,000 or 400,000. But if you look at the statute, which is what a lot of personal injury attorneys look at, guess what? It still contains the amounts that were there from 2000, the year 2000. And so I've literally had attorneys that send a demand letter to my client saying, my client will settle this for the 250 cap. Oh, let me talk to them about that. They haven't, and the reason they don't know is because the Governmental Immunity Act references the fact that there's going to be a multiplier. It actually sets out a very boring formula, if you care to follow along, on how that's going to be calculated. But you've got to go to the Utah Administrative Code to figure out what that number is every 2 years. And I have it in the materials. It's not a secret, but that's not apparent from the act. So I'll leave it to you to do what you want to do. If you get somebody that says, my client was severely injured, he'll take the 250 cap. And one other thing that a lot of people don't know is the cap, per person cap, applies regardless of the type of claims. So let's say, this is esoteric, but somebody dies. They have in Utah what's called a wrongful death claim. They also have in Utah what's called a survival claim. The survival claim belongs to the dead person. It's to compensate them for the amount of pain and suffering that they went through between the time of the accident and the time they died. And so if you lingered in the hospital for a long time, you might rack up a lot on the survival side. The wrongful death claim belongs to the heirs of the estate. And in Utah, and there's only a few states that do this, your wrongful death claim is guaranteed by Constitution. It's not derivative of the underlying claim. So regardless of whether you're bringing a claim for the dead person's survival claim, pain, suffering, everything right before death, or whether you're bringing the claim on behalf of the heirs for their loss of association, affiliation, affection, and support, that's all the same thing under the cap. That's not two separate claims. Similarly, if you're bringing the claim against multiple governmental entities, the cap stays the same. It's per person, not per entity. And I've had two wrongful death cases the last few years, both drownings, that we had to explain that to the other lawyers, but all of the entities that were involved, we had the state, the county, the city, water entity, everybody agreed that that's how the cap would apply. And there's a couple cases out there. I think Deland versus Bott is the main support. But a lot of lawyers, personal injury lawyers, don't know that. And so we went to the mediation on this case involving a wrongful death with a cap of $770,000. And their first offer out of the gate was 1.5 million. And everybody went, okay, what do you want us to start at? You know, 20 bucks, 30 bucks, it's imaginary money, right? And so those are things to know if you're trying to resolve a claim. It's good to know what the actual limits are, what the actual caps are, what they apply to, and how they apply. That is my flying overview of the Act. There's a couple of other things that are probably not worth giving you in the overview, so I'm going to try to multitask. I know Chris did a much better job at this than I'm going to do, but you just press the down button there, Chris? Is that the deal? Okay. All right. So section 101 is the one I was telling you about. You go down here, this is what it says. It applies to everything you do as a governmental entity, right? But the important part is right down here. And that says that you retain immunity described in 201.3 and 201.4, even if the immunity is waived under 301. You wouldn't know that unless you read the very first part of this. So you get to, these are the definitions I told you about, section 102. And the only one that's really worth talking about is, again, the legislature had to find 3 different ways to explain what a governmental function was. So they really meant it. Then you get to 201. This is where the good stuff starts. Okay, this says, okay, first one right out of the gate. You're immune if you're doing a governmental function. Trust us. But you go down a little bit further, and we don't have to talk about things like epidemics and pandemics and things that obviously make sense for emergency immunity. The next area that you get immunity for is what's called latent defects. So if you have a latent defect of a highway, road, alley, crosswalk, sidewalk, I can't think of a public structure that doesn't apply here, or latent condition of a public building, structure, dam, reservoir, etc., you get immunity. Latent defects are defects that are not apparent. They're not patent, they're not observable. So if you have a bridge that looks like it's great and it's really got some sort of cracking going on that's not apparent and it breaks and kills a busload of kids, you can claim that it was a latent defect. The flip side of this, as you'll see later, is that immunity is waived if it's not a latent defect, if it's just plain defective. All right, this is the big list. This is the stuff that qualifies for immunity. And despite the fact that the coming section says we're going to waive your immunity for negligence of your employees, not true of this. Because section 101 said, this section you're looking at now is going to trump the waiver that's to come. So we talked about discretionary decisions. And those are the decisions that are budgetarily based, policy based, planning. So if you get sued for something that you put some time into, that you had committee meetings on, that's budget policy based, you need to preserve that evidence in order to defend on a claim of discretionary function. For example, there's a case that I think it was UDOT was redoing a section of road, highway, had Jersey barriers in the middle. They could either remove all the Jersey barriers and resurface the road, or they could leave the Jersey barriers in place and resurface the road, which was going to either way raise the road by about 3 or 4 inches. They chose the latter. They did a study, yada, yada. It's better if we do it, just leave it. Well, as fate would have it, and I didn't know this at the time, Jersey barriers are actually specifically designed to be a certain height off the road and to have a certain curvature once you hit them. And if you raise them up, if you raise the surrounding pavement too high, they don't work like they're supposed to work. Well, that happened. Somebody hit one of these Jersey barriers and sued the state. And the state came back with discretionary function, and they were dismissed on immunity, even though it was undisputed that that decision was the cause of this accident. So I always try to tell my clients when there's a claim that involves a question of your decision making. This is like the water conservancy case I was telling you about that had to decide what sections of pipeline to replace. Did you give some thought to this? Is there something in writing? Did it involve a financial analysis? Those are all good things to preserve if you're getting sued for a question that you spent some time on. What isn't a discretionary function, and this was actually argued in a couple of cases, was, okay, the officer's decision to draw his firearm was a discretionary decision. No, it wasn't. That was a spur of the moment thing. Maybe they did the right thing, but it's not a discretionary function. Okay. B, guess what? Assault, battery, slander, libel, deceit, interference with contract, infliction of mental anguish, immune. Now, one up here that's a little bit misleading is the violation of civil rights. That might be true if it's a civil right based on the Utah Constitution. This doesn't get rid of what we call 1983 claims. It can't. Does everybody know what a 1983 claim is?
No.
So Section 1983 of the Civil Rights Act provides for a cause of action against a governmental entity or its employee based on a violation of their civil rights. It's the 14th Amendment pulling up the rest. And so if you bring a claim in federal court because you think that a public official violated your civil rights and you bring it as a 1983 claim, that doesn't mean anything up there, what's on the screen. But 1983 claims there's great defenses to those, and it wasn't part of my presentation, but basically to prevail on a federal 1983 claim, the plaintiff is required to show that there was prior precedence from the 10th Circuit on the very fact pattern that you're alleging was the violation of your rights. And if the plaintiff can't come up with that, then they can't prevail against the governmental actor. And a second way you can prove that it's the policy or procedure of the governmental entity to do whatever you think they did wrong, but they're dang hard to win. So anyway, that's my diatribe on why Utah law doesn't trump federal law. I highlighted most of the ones I've used. So if you issue, deny, suspend, or revoke permits, licenses, approvals, applications, or similar authorizations, that's an immune function. And I've defended those cases right and left because someone always questions whether, I had a case where somebody built a house with a certain grade and they sued the city for granting the permit because the grade resulted in water running over their property and into the neighbor's yard. And so authorizations, permits, all that, usually immunized. Making inspections, failure to make inspections, making inadequate inspections, immunized. I'm going to talk about judicial proceedings, misrepresentations by employees, whether negligent or intentional. So you call up some government helpline, they tell you something, you do it, it's wrong. That's an immune activity as well. Natural condition of publicly owned or controlled land. I had a case that got defended the town of Olympus successfully at the Supreme Court because avalanche came down, they stopped traffic, brought down a cat from Snowbird. While they're waiting for that to show up, another avalanche hits, takes a bunch of cars down the hill with them, and the Supreme Court agreed it was a natural condition of public land. Interestingly enough, a few years ago, there was a tragic case of a kid that got killed by a bear in, what is it? There you go. And there had been a bear spotting. Division of Wildlife Resources and others came out, tried to find the bear, couldn't find the bear, came back to the place, told everybody it's safe to come back, the bear's gone, the bear kills this kid. Nearly the same place that appeared originally. And they tried to argue in that case that the bear was a natural condition of publicly owned land. The Supreme Court did not agree with that natural condition of publicly owned land. But avalanches, sure. This was my favorite. The legislature, I'm not sure what prompted the pedestrian or equestrian trail along a canal, ditch, or stream, but there's a bunch of requirements you got to meet before you can get immunity for that. So if any of you are involved in a pedestrian or equestrian trail along a stream, canal, ditch, etc., and you want to be immune, you should read the requirements of this, because there's some things you have to do. It just can't be as simple as, oh, it's our trail next to a creek. But I'm not going to go over those right now, other than to tell you. What is that? Okay. Management of floodwaters, earthquakes and natural disasters. Everybody, anybody here remember the 83, 84 floods in Salt Lake? I used to work at the Hotel Utah and had to carry my bike across the bridge over State Street. It was crazy. That's why we got that one. Management of floodwaters. Interestingly enough, there was a tragic case a couple years ago involving a highway out by Wolf Creek Pass. I forget the name of the town that's close by. Hannah, who said it? Hey, this guy, you want to take over here? The water had eroded the roadway. And tragically, a car comes along, drives into it, and there's a death. And they tried to argue that this was management of floodwaters, and the Supreme Court disagreed. So you can use it, but don't try to turn a sow's ear into a silk purse. Flood and storm systems, obviously. Operation of emergency vehicle. Is there any public safety people here? Oh. So I've defended a number of those cases. And if you read this, it says, okay, you're immune as long as you're operating this emergency vehicle driven in accordance with that section of the Motor Vehicle Code. That section of the Motor Vehicle Code says your lights and siren have to be, your lights have to be visible for X number of feet. Your siren has to be audible up to certain decibels. However, at the very end comes the gut punch, and the gut punch is nothing in that section relieves the operator from a duty of reasonable care, which means that every time you get in an accident running lights and siren in an emergency vehicle, there's usually going to be a question of fact as to whether or not the operator was using reasonable care. And as many of you know, reasonable care not only depends on what is reasonable to the average person, it also depends on what your policies and procedures are for running code. And I've defended a few entities who had a stop policy at a red light who were maybe 40 miles an hour beyond stop at the time of the collision. So if you violate your own policies, that's not going to help you either. But just as a general rule, operating an emergency vehicle with lights and sirens is not going to get you automatic immunity. There's probably going to be a question of fact. The other two are pretty obvious: emergency medical services and firefighting. We had a case 20 years ago involving a case up in Ogden where a fire chief was going to a fire and went through the intersection against the light. It depends who you talk to, 30 to 40 miles an hour, busy intersection in Ogden, crashed into another car. He was headed to a wildfire. It was about 4 miles away and up the road. We argued to the Supreme Court that was an activity, he was engaged in an activity of fighting fire. The Supreme Court came back and said, maybe, but he was also mostly engaged in operating an emergency vehicle. And he didn't do a good job. So you're not getting out on immunity on the firefighting thing if you get stung on the operation of an emergency vehicle. V, here's the one from the bear. So guess when this was added? The year after the state got sued for the bear attack in this place? That one. It wasn't Spanish fork, it was American fork, that's right. Anyway, now they're saying the activities of wildlife they're immune from. That hasn't been tested. I don't know. This last one was just added the last legislative session. Law enforcement agencies can actually talk to each other about employees, former employees, discipline, all of that. As many of you may know, there was some handcuffs, wrong analogy. There are some constraints on that. And it used to be that officers who were under investigation could resign and the investigation ended and start with a different agency. And this is a way that the agencies can communicate without having liability. All right, here we get to the public duty doctrine. And it says, act provisions not construed as, okay. Nothing contained in this chapter. Okay. B, if immunity from suit is waived. Oh, we're not there yet. I'm just reading the caption, I'm sorry. So the part that I highlighted in red means that if you don't have immunity, you're going to be treated as though you're a private entity. Private entities do not have damage caps. That's the thing to keep in mind on that one. Okay, probably don't need to talk about this, but it's happened recently and I don't know why. And that is some lawyers feel constrained or entitled to not only bring the claim against the governmental entity, even on clear liability cases, but to also name the governmental employee. And I don't know why they do it. It's happened 3 or 4 times in just the last year. And the Immunity Act says you can only do that if they're drunk, if they're high, if they're willful, malicious. And I'm not going to read the whole thing to you, or they committed fraud. But as a general rule, they shouldn't be suing your employee. As long as your employee is acting within the course and scope of their employment, they don't have to do that. And it's subject to dismissal. However, I'll tell you, I like to wait and not do that up front. And the reason I like to do that is I've had cases where, well, first of all, you have to raise it as an affirmative defense, right, in your answer to the complaint. I'd say 50% of the opposing counsel actually read my affirmative defenses, so they might do something about it. But if they want to sue the employee, if they think there's some advantage to actually having a cause of action against the employee, I wait till fact discovery is over, because I've had it turn into straight negligence claims against the governmental entity. And then suddenly, in the face of a motion to dismiss the claim against the employee, now they've got a negligent hiring, they've got a negligent supervision claim, they have some sort of claim that that person shouldn't have been working for you. Or they have a claim that that person was outside the course and scope of their employment. And so I like to sit back and wait. I'd say 90% of the time, you never hear about it again. But I just resolved the case that it was a governmental entity, the driver was in the course and scope, in the entity's vehicle, ran a red light, got a ticket, actually got terminated, and they still felt compelled to include him on the complaint. So I don't know what the thinking is there, but just know, if one of your employees gets sued, they're in the course and scope of their employment, and they're not drunk, high, committing fraud or willful malicious conduct, they don't have much to worry about. You should pick them up though, and this, Chris will tell you this too, as an insured, because you want them on your side, right? You want to be able to talk to them and not have them say, yeah, I wasn't supposed to be doing that. Yeah, that was our policy to do that. Yeah, it was our policy to run red lights. We had a contest. You don't want that getting out of hand. This just goes through false testimony, drunk, high, malicious. This is the general rule. All right, 5 is the public duty doctrine. And the public duty doctrine is, let me go down here. Well, give me a chance to catch up. All right, so the public duty doctrine, as the name suggests, was a creation of common law, not legislation. The doctrine, however, has been added now to the Governmental Immunity Act, but most of its interpretation, in fact, all of its interpretation has been case law. And basically, the doctrine is premised on the idea that as governmental employees, you have a public duty, right? Someone calls, you can't tell them, I'm sorry, I know in your cities, whatever, but you know, bugger off. You have an obligation to do stuff in the role of being governmental employees, leaders, whatnot. And the doctrine basically says, look, it would be fundamentally unfair to hold public employees and public entities accountable for every single misstep they do simply as part of their public duty to carry out their job. And so it's a policy-based exception, and there's case law that says, look, this would act as a disinclination for people to want to work for the government if they said, wait a minute, I'm only talking to 100 people a day and they could sue me? I'm not doing this. So the doctrine is, if you're performing a public duty, as opposed to a specific duty for that person, you can get out on immunity based on the public duty doctrine. And it requires the plaintiff to show that you owed a specific duty to them as opposed to the general public. So I have a case right now where, and it's been briefed and we're waiting for the court's decision. There's plenty of Utah cases that say firefighters and police officers are performing public duties. So if they come to your house and they knock down the wrong door because they think the fire is in a different room, you're not going to be able to sue them for mismanagement of fighting that fire. They were doing their public duty. They're fighting fire. Same with cops. There's also a case on a dispatcher. And this dispatcher, this occurred in San Pete County. The dispatcher gets a call from somebody reporting, a 911 call reporting that a large deer carcass is in the middle of this 2-lane road. And it's the dispatcher's job at that point to notify, in this case, UHP, who then is in charge of getting the carcass out of the road. I don't think the troopers do it, but I'm sure there's a system that they've got in place. Maybe the troopers do it. Regardless, the dispatcher took the call and did not contact UHP at all. And as fate would have it, within the hour, a car swerves around the carcass, runs into another oncoming car, and 2 people die. And San Pete County got sued because the dispatcher did not dispatch UHP. The Utah Supreme Court held that dispatchers who receive calls from the public on emergency lines are performing a public duty, and therefore upheld the grant of immunity against the county for not dispatching anybody. We have an interesting case now that we're waiting for a decision from the court on, and that is I represent a dispatch agency that dispatched to a welfare check, and they're being sued because they supposedly didn't supply all of the information that the caller reported when they called. And if you know anything about dispatch agencies, you might have to go through 2 minutes of information that you're not going to want to include on your dispatch of the police officer, right? And so the theory is that the dispatcher should have included this extraneous information from the caller, and that's what caused the accident. We argued public duty doctrine based on that San Pete County case, right? Well, in this case, the court in that, it's called Simon's case, San Pete County said, receiving 911 calls is a public duty and you're immune. They actually argued, the other side actually argued in this case that because we actually did something in response to the call means that the Simon's case doesn't apply. It's like, well, you got to do something, right? I mean, in that case, literally the dispatcher said, okay, we'll get someone out, and forgot about it. In our case, the dispatcher said, okay, we'll get officers to the welfare check, called the officers, gave them the information, they showed up. So the theory in this case is that we didn't provide enough information. Globally, though, the argument is dispatchers are doing public duties. You know, they're the glue that holds firefighters and police officers and public safety, keeps them on the same page, holds them together, gets the basic information. For about 9 years, the public duty doctrine was interpreted to apply to both omissions and commissions. Most people know what omissions are, but commissions is actually an affirmative act of misconduct. That is no longer the case. That was changed. The case that set it up was Webb. I forget the case that struck it down, but it only applies to omissions. That's important because the other side is going to argue, if they're trying to get around the public duty doctrine, they're going to argue that you did some affirmative act that took you out of it being an omission and turned into a commission. And my dispatch story that I just told you about the dispatcher actually doing something was the argument that was made, oh no, that's not an omission, that's an affirmative act. In San Pete County, the omission was not calling UHP. In your case, though, you actually said something to the cops, and they actually showed up. Jeez. Keep those behind me. So anyway, keep that in mind. It is, in my experience, the most overlooked defense that public entities pursue. It's amazing how many cases I've had where I don't think defense counsel even raised the public duty doctrine as a defense when I thought they should have. That has changed in the last 10 years. It's changed, I think, a lot because it's now specifically codified in the Immunity Act. All right. So I list the types of, sorry, thinking you guys are looking at what I'm looking at. Okay, so we list the various types of activities. I've talked about them before. Regulation of financial institutions is included. Parole board decisions. These were a lot of the early decisions. The parole board would decide to parole somebody. They would get out and promptly kill the person that was responsible for putting them in prison, and the parole boards would get sued. Natural disasters, safety inspections. Okay. All right, so to overcome the public duty doctrine, the other side has to establish what's called a special relationship. And there's 4 ways to do that. Obviously, if there's a statute intended to protect that person or class of persons, think motor vehicle code, you shouldn't be driving 90 miles an hour with your lights and siren not on, or if you work for the mosquito abatement district, maybe 90 miles an hour, there's a statute that says you shouldn't do that. The one in red is the one I most commonly see. And they will argue that you've taken steps to protect that person or their property. And this was an argument they made in the dispatch cases. So dispatcher gets a call, welfare check on so-and-so. Okay, 1 Adam 12, can you go check out this welfare check? Okay, the argument now is, okay, you just undertook specific action to protect that person, so you're no longer entitled to the immunities of the public duty doctrine. It's a poor argument in my experience. But I've had cases where, I mean, you can see where this is going to apply. This is going to apply to if an officer arrives at a scene, automobile accident, and says to Joe Blow, I want you to stand in the middle of the road, don't move. And Joe Blow gets run over. You undertook specific actions to protect the person or property, maybe not the right actions. I've had these on prison transport cases, a case where somebody claims they wanted to be seat belted and they weren't, and as fate would have it, they get in an accident in the parking lot of the court. Side story on that case, if you're going to go to court on a matter, try to make sure that you don't have a bench warrant on another matter, because they tend to check those kind of things. Really, this lady showed up, I think, to be a witness in a case, and bailiffs were talking. After the case was over, they kind of went, turn around. She had a bench warrant, so she got a ride from court to jail, and that's how she got in an accident. The other two, if you induce what's called detrimental reliance, you make somebody rely on your information. So for example, let's take a case where you think a hillside is about to come down. You call your city, they send out some guys to look at the hillside. They say it's perfectly safe, you stay right there. And the next day they get crushed in a landslide. They probably did something to induce detrimental reliance by telling you you're fine staying right there. Yeah, and don't hurt people if they're in your custody. Fourth one. So we talked about the aging water pipeline. Trial judge thought that was a public duty. Dispatcher who fails to dispatch for the deer, public duty. Officer fails to guard an assigned crosswalks. One of the cases that happened about 20 years ago. A couple cops get assigned a crosswalk up at the U after a game at the Huntsman Center, and it's raining. They don't want to stand in the rain. They're sitting in their car. Somebody gets mowed down in the crosswalk. Court said, that's okay. Public duty doctrine still applies. You didn't have a specific duty, and they tried to make it specific. You owed a duty to people in this crosswalk. And our Supreme Court said, no, not good enough. Officers respond to severely intoxicated woman and instruct her husband to let her sleep it off and not call them again. This is a case that happened in Provo. It's a reported case, and that's exactly what happened. In fact, they threatened to arrest the husband if he called back. The husband called, thought his wife was suicidal, was trying to take drugs, was obviously drunk, and they said, put her to bed, don't bug us again. If you do, we're going to arrest you. That was not public duty. You sort of went outside the scope of what you were supposed to be doing. So that's the Fauchot case out of Utah County. There's the bear attack. you undertook action to protect a specific person by telling the new campers it was okay to camp where the bear had just torn somebody's tent apart. That took you outside of the public duty doctrine. Oh, my favorite. So this is Utah Valley, it wasn't university, it was Utah Valley State College at the time. Ballroom dance instructor wants the dancer to do a certain lift and throw with a partner without spotters, and she gets hurt. Sues the college. And they analyzed whether it's a public duty doctrine case. Court really didn't get that far because the court said, guess what? Ballroom dance instruction is not a governmental function. So as much as it was a state college, a governmental institution, you weren't really doing anything governmental by instructing how to do ballroom dancing. How are we doing on time, Brian?
We're about 5 minutes.
Okay. All right, so the last thing I wanted to talk to you about was what is called the limitation of landowner liability case. And this is a statute that says, and it doesn't have to be governmental, it can be private people. If you let the public use your property without charging them a fee, and they get hurt, you're immune. As long as the injury was directly or indirectly caused by their recreational activity. So I'm trying to figure out which page that's on. Just a second, bear with me. Say again? No, it's not the, well, I think it used to be called something like that. It is officially now the limitation on landowner liability. It's on page 49. Oh, I want to show you this. This is a screenshot from, so this is the Utah Department of Corporations website. And you'll see I have a device for this. Watch. This is great with my golden retriever. See that? You hit the search bar and you pick from that list a drop down Governmental Immunity Act database. And I typed in Washington County and it gave me 4 choices starting with that. I chose the Conservancy District. And it gave me Roberta McMullen as the proper person for service of a notice of claim. I talked about this earlier. You have to give the Department of Corporations a contact person for your notice of claim. If you don't, or you don't update it, your lawyer cannot use that as a defense if they just leave it with anyone in the office. So I've had clients, believe it or not, that had people listed that were 4 directors ago. So a lot of people forget to update this. When this first came out after the 04 rewrite, everybody complied and then forgot about it. And the Department of Corporations is not in the habit of reminding you to update your stuff. So if you want those defenses under the notice of claim provisions, then find out who you've listed. Now there's a couple ways to go about that. You'll see in the section 401 and 402 that we talked about earlier, it says if you're a county, serve this kind of person. If you're a city, serve this kind of person. And so there's usually a couple ways to serve the notice of claim. But if somebody relies on this way, and it's not up to date, you got a lot of explaining to do. All right, let's see. We talked about most of this. Hey, and if any of you have questions, please interrupt. This is the part I was talking about earlier with the You have to go to the Utah Administrative Code 37.4-3. It lists all those years. And I just highlighted the last set of 2 years. That is what shows you the applicable limits for accidents occurring after July 1 of 2020, July 1 of 2018, July 1, 2016. You can see how those amounts go up. That will tell you where the caps are if you check that. Let's see. Talked about that. What did I say, 42?
Question.
Yes, sir.
Super type question, but safety inspections not mandatory now, does that change anything or added any complexity to the lack of a requirement for safety inspection for vehicles?
You mean the fact that we don't have to do them anymore? Yeah, I've not seen that, and I think you'd be, frankly, if you're authorized to do safety inspections for the state and you did a bad inspection of a car and it got in an accident, I think you're still going to be immune under the inspection permit portion we talked about earlier. But good question though. Okay, here we are. Limitation of landowner liability. This is the purpose of this act. Limit the liability of property owners for people entering their land as a trespasser or as a recreational user. So cities, counties, you have a lot of property out there that people like to go hurt themselves on, as long as you're not charging them to hurt themselves. And they're recreating. This act probably affords you quite a bit of protection. We've argued this in 2 back-to-back drowning cases, wrongful death cases. And the first was a guy that went over a low-head dam, and we didn't think the act would apply there because the danger wasn't apparent. The second one was a case that we just got dismissed from. It was a lady and her husband were walking their dogs in Parley's Historic Nature Park. Has a dog park, open dog park. It was during spring runoff, and the dogs went into the pool. I don't know if any of you have been there. Anybody know the park? Right. Right at the mouth of Parley's Canyon. It's spring runoff where daylight from underneath 215 comes out of a culvert, big pool of circulating water. Her dogs jump in, they're having a hard time getting out. Her husband jumps in, tries to get the dogs out. He can't get them out, he barely gets out. So she jumps in and drowns. And we were dismissed on the Limitation of Landowner Liability Act in that case. They sued every property owner that had anything to do with the park. Salt Lake City, Salt Lake County, Metropolitan Water District, UDOT. UDOT owned a little chunk that they had to own in order to build 215 back in the 60s. So this act worked for everybody. And the wording of the act at the time was not as friendly as it is now. Basically, the wording now is, as long as the person is injured directly or indirectly as a result of their recreational activity, then you're immune. It used to be that how they were injured had to be an inherent risk of their recreating activity, which always conjured up fanciful creations of what inherent risks are of various things. Land, broadly defined. Land can include water, and structures. Recreational purpose. Here's your list, boys and girls. If you think of something that's not on here, you'll be the first. This was an interesting issue. You'll notice that serious physical injury does not actually say death. It might create a risk of death. There it is, I see it. So when this case first got filed, the case went up on appeal because the plaintiffs said this statute does not apply to wrongful death claims because death's not listed as the serious physical injury. And the Supreme Court shot that one down and said it does. They also appealed it. This just came out 3-4 months ago. They also appealed it saying that this violates the Utah Constitution's guarantee to bring a wrongful death case. I told you earlier, we're kind of unique. There's only a handful of states that constitutionally guarantee that. The Supreme Court also said, no, it doesn't. Okay, let's get to the good stuff. Okay. Pretty strong language. The owner of land owes no duty of care to keep the land safe for people entering it for recreational purposes, or to even warn them of a dangerous condition, use, structure, or activity. And I said there, spoiler alert, because these two are exceptions to that. You can't be intentionally, willful, or maliciously harmful to people, believe it or not. And if you, oh, this is the other one that's found interesting. If you're leasing land from someone, that's not considered a charge for recreational purposes. So the argument has been made, okay, West Jordan was leasing this to such and such company, therefore they were charging for the recreational use, and of course the statute says, no, that argument's not going to fly. And this is the guts of the statute. So the owners are not making any representation, not conferring any legal status of invitee, licensee, not assuming responsibility, and not owing any duty to even stop people from using it for recreational purposes. This is a beefed up statute from what it's gone through about 3 different iterations where it's just gotten stronger and stronger. So if something happens on your property and somebody's recreating, and recreating could be walking, remember the statute. How we doing, boss?
Pretty well there.
What's that?
We're pretty well there. We got the.
Okay, I can stop anytime. Just tell me to quit. Anybody have any questions? I'm going to stop. Thanks for listening to me. Okay, no questions? No questions?